I pay for the petitioner. In 2020, there was a demand for the same quantum. Demand was withdrawn. Fresh demand issued, that was set aside. This honorable court then not fresh order was passed. Then a person not inimical to us files a complaint for Lokayukta. Now the officer concerned restores the same demand and sends it to us. At page 28, the 2020 is referred to because he's summoned by Lokayukta. He says, I'm issuing the same demand to you.
There's a connected petition that is already pending before Lordship.
That is true. That is earlier, after the determination of what was due.
Same demand. If I can't complete my petition is incomplete. No, it is. The impugned order is not forthcoming incomplete here.
No, this is on the demand. The earlier demand was.
Early demand is at page 58.
That was disposed of.
That is disposed. That they withdrew. They withdrew, issued a fresh demand, that was set aside. Then, Lord, we were heard, and the determination was about 50 lakhs. And that was challenged before the honorable court, that's pending.
That is on 3rd September 2022. There was
the 3rd September demand, which is of 57 lakhs, which is pending. So it may be allowed, it may not be allowed, we don't know. It's pending before this court.
This court, before your lordship.
So tagged on along with that. I'll check your instruction. What
date is that?
That no, I don't think there's a date. It's a 2022 petition.
It's a list, issue notice, list along with WP
23735
2000
23735 of 22.
Yes.
No, it's 7898.
No, that is the disposal.
That is the 23735 of
23735 of 2022. That is the demand notice dated 3rd September 22.
Page 72.
Yes, 23735 of 2022 bracket GM-NM-S. On that.
This may be stayed, this demand.
Yes.
This demand may be stayed in the meantime.
What is there any steps being taken?
No, they will. This is the beginning of it. The direction to pay within 7 days, failing which action will be taken as per law.
I will instruct them not to precipitate.
In the meanwhile, no precipitate steps be taken in respect of. Is there a stay in that matter?
In that law, no.
There is no stay.
Any precipitate to recover the additional demand that is over and above the demand raised. Demand dated 3/9/2022.
Great.
2nd November. Still number 14 of list 2. Still number 14. Mr. Rajati Sadashivan. Rajaditya Sadashivan.
Yes. Able to get your bank rate? No.
My apologies, my lord. The notifications I've got.
So how much should be the respondent is not there. We'll hold it over, let the respondent let it counsel.
Still number 16.
16 will. Mr. Panindra, we'll just take 2-3 matters more and start it.
Please. List one, cell number one.
To the petitioner, my lords. The petitioner had submitted a representation to the respondent number 3, my lords, to renew the acquiring license issued by the respondent number 3, my lords. The respondents have issued an impugned endorsement stating that, my lords, the property of the petitioners comes under the Tipgondanelli Reservoir catchment area, my lords.
Yes.
Thereafter, my lords, the petitioner has obtained the details, my lords, by under the RTI Act, my lords. It is in page number 64, my lords. Page number 64, serial number 8, my lords. The petitioner property is situated at Agala Guppe village, my lords. Here, in the list of villages, serial number 8, my lords. That is Avala Guppe, my lords. Avala Guppe is 5 kilometers away from Tipgondanelli Reservoir, my lords. The petitioner property is 35 kilometers away from the reservoir catchment area, my lords. The respondents have wrongly.
We are not able to find it. Your last thing was 1994. What happened after 1994 to 2022?
Due to certain circumstances, I had stopped the acquiring activities, my lords.
From when? When did you stop your acquiring activities?
From 2001, my lords. My claim was rejected based on the
You also refer
wrong
to a
assumption.
writ petition that you had filed. What has happened to that?
The petition was allowed, my lords. The authorities were directed to renew my license, my lords. Subsequently, it was renewed, my lords.
Where is that order?
Order have not produced.
You will have to give us some dates. It can't be this sketchy. Nothing that we can figure out from this petition. You say the petitioner was absolute debtor, dated nil. The petitioners have been granted, dated nil. Petitioners have paid royalty, dated nil. And then 1994, you say there's something. Writ petition is filed, interim order is passed, interim order is a status quo order, then there is no information as to what.
Produce the license, my lords.
To take instructions.
And work order also, my lords.
Then the AG accepts notice and seeks time to take instructions. This time, put it after the week. 10 days.
Impugned order may kindly be stayed, my lords.
25th August. Says cell number 10 of list one.
Writ appeal 2005 was the first matter. Tender notification was dated 25th of October 2017. Their tender was dated 8th of December 2017. Both matters are after 1st of July 2017.
And the notification is dated?
25th of October 2017. The tender was submitted on 8th of December 2017. And contract, my lords, was entered into on 28th of February 2018. All of which, my lords, is after introduction of GST. Then was they file a representation seeking the difference between what the prevailing VAT rate prior to 1717 was and once we don't consider, they file a writ petition, and a mandamus is issued to reimburse the amount specifically stated in their representation. I will find that the operative portion is at page number 18 and on the basis of Chandrasekharaya.
Yes, how does even Chandrasekhar Iyer apply?
My lords,
How does this judgment apply?
my lords, I'll just point out, my lords, few discrepancies, my lords, in their agreement, my lords. My lords, kindly see their agreement, my lords. Their agreement is page number 37. Or they say that, my lords, SR rates of 2016 and 17 are applied. And my lords, while giving the GST amount, my lords, they have not even calculated the GST tax, which was 8% difference. My lords, during the SR rate, my lords, only 4% VAT was applicable. Only 4% VAT was applicable, my lords. Now, when I claim the amount, my lords, in 2019, 20, and 22, my lords, I have paid the GST. And therefore, my lords, Chandrasekhar Iyer judgment says that, my lords, after the GST regime, my lords, if the bill has been given for the sanction and the sanction is obtained, then, my lords, it should include the component of GST, which is 8%. That is the differential GST. Now, my lords, what they say in their opinion also, my lords, is they have calculated their computation based on the VAT regime, my lords. They have not even considered GST into the consideration. And, my lords, no, my lords, another.
You have agreed to this price of 317,41,000. Execution and completion of the works at a contract price of 3,17,41,000.
Please, my lords.
That's right. That's what you have agreed to.
That's what we have agreed to, my lords.
Where did you agree that will be you'll get GST extra?
My lords, in their contract, my lords, they should have specifically mentioned that.
It is not their contract. It is your contract.
The agreement, my lords, within the
Where
agreement.
did you specifically mention that you will charge GST extra?
No, my lords, in our GST R1 and 3B, we have already paid excess GST.
Where in the contract does it say you will get GST extra?
There is no mention in the contract, my lords.
Right. Now,
But, my lords,
if you have a contractual dispute, you will raise it.
Yes, my lords.
This is not Chandrasekhar Iyer, no application in this.
Now, my lords, what has happened is in Chandrasekhar judgment, the respondents were the KAS and KHB, my lords. And, my lords, they were also respondents in that particular writ appeal. Therefore, that judgment is binding upon them.
Which writ appeal are there?
Writ appeal, my lords, 718 and 71615. I'll pass out the judgments, my lords. Kindly see at page number 89 and page number 13. And my lords, they are parties to this writ appeal. So kindly see page number 81.
Yes.
No, sorry, my lords, not 81.
Yes.
Page number 81 KHP. Page number 89, my lords.
Yes. Yes. 89 is a part of our order. 89 is a part of our order.
Yes, my lords. Part of writ appeal. The whole impute judgment says that, my lords. It is a part, KAS and KHP, my lords, both are the part of this particular judgment. Both respondents are part of this.
Which particular judgment are you
My
referring
lords, judgment at page number, judgment
to? Writ appeal number.
617 and 718, my lords. 618 and 718 and 615.
All right. You look at 718. What does the judgment say?
Also, the judgment says that. Well, I will point out the specific paragraph at page number 18, page number 13, 18 para. The dispute as to whether the writ petitioners is entitled to reimburse the incremental tax paid or payable by them on account of levy of GST is strictly a matter between the writ petitioners and the concerned employer with whom he has entered into a contract. The contract between the writ petitioners and the employer who would not alter the statutory schemes of the levy GST. Thus, the liability of the writ petitioner to pay goods and service taxes, whether under the Central Goods of Tax Act 2017, States Goods of Tax Act 2017, or integrated tax, is required to be determined strictly in accordance with provision of relevant statute.
That's right. Correct. This is the writ petition that the state government had filed on the ground that
They can't be a
suddenly
direction
revised
to the-
returns have been permitted. Under which statute we did not know. So we said, obviously, it doesn't Any observation can only be construed against the employer.
Employer, it is already mentioned over here, my lords. Kindly see.
That's why
At para 20, it says that, my lords, the direction issued by the respondent to reimburse the tax is required to be construed as a direction only to the concerned employer and not to the tax authority.
Correct. This is the appeal of the state. So state
My lords, because I have
under which judgment?
but there are various other judgments, my lords. I've listed various other judgments as well.
Yes, under which judgment will the employer?
There are other petitions number 36455. There are altogether 21 judgments, my lords, which are produced before this honorable court. Where it says that
Tell us where this contract is covered. In this contract, where is the decision
all-
on this contract?
all the writ petitions whichever I produced, my lord, the contract was entered after the VAT trade, and there was no mention of GST.
You have a contract, no? First of all, you shouldn't have come in a writ petition in the first place, but you decided to come in a writ petition.
Please, my lord.
You got an order in this contract getting a stay. You tell us which is that decision which is granted you stay apart from the one which is covered under this particular appeal.
But it's a very 718 judgment. The respondents are the parties, my lords, wherein
That's
the
right.
judgment itself says that
Respondents are a party, therefore they're not precluded from filing their own appeal. As and when the appeals have come from the parties, they've in some way have expressed, stated, they clarified this also.
but in the para 3 also what they say is, my lords, they have entered into contract before the VAT period. And my lords, what they say
Not
is,
relevant for us purposes. Not relevant. It is
but
not
what
even
they say is,
considered.
my lords, because of the burden of the finance, they are not able to pay the GST. Is what they claim in the appeal.
Just take down. The appellant has filed the present appeal, impugning an order dated 26 March 2025, passed by the learned single judge in writ petition number 35531 of 2024, bracket GN-PN, bracket close. So that is, said petition was allowed. It's fine. The respondent had filed the said petition. The directions be issued to the appellants, like the respondents in the said case. Respond number 2, Mr. Directing the respondents, directing appellant and respond number 2. Arrayed as respondents in the said bracket, arrayed as respondents in the said petition to refund the differential GST amount paid by the petitioner in respect to the works executed by them. The prayers as made by the petitioner and as used in the impugned order set out below. The learned single judge, and without adverting to the facts, allowed the said petition by referring to the decision rendered in WP 9271 of 2018 and other connected cases. Bracket that Chandrasekhara and others versus State of Karnataka. Footnote 2020 neutral citation 2023 KHC 1415431. The appellant's learned single judge is directed the appellant to appellant and respondent number 2 to reimburse the GST amount as claimed in the representation dated 21/11/2024. Good start. So the said representation is being placed on record.
Make one request, Manas.
Has been placed on record, which indicates that the petitioner had raised various writ petition. That is, on one had raised various bills of in respect of construction of DC Post Matric Girls Engineering Hostel at Kadwa, Uttar Kannada, under a contract agreement dated 28/2/2018. It's also stated that the petitioner had paid, the writ petitioner had paid CGA, an aggregate CGST amount paid amounting to rupees 12,99,699 and SGST of rupees 12 for the equivalent amount. Full stop. The petitioner stated that since the contract was executed after 1/7/2017, on which the GST regime was rolled out, was entitled to reimbursement to this. Let's start. Next part. The brief facts are that the this is the petitioner, it says tender on 8/12/2017. The same was evaluated and petitioner was declared a successful bidder. Thereafter, on the parties entered into an agreement dated 28/2/2018. The work order, the said agreement indicates that the appellants had the directions issued in the case of Chandrasekhar Iyer would be dash, which is the sole basis on which the writ petition is allowed, dash, would have any relevance, would have much relevance.
I'm sorry to
Without going into it's also not necessary to go into the question because it is clear that the dispute whether the petitioner is entitled to GST, reimbursement of GST paid by it, the impugned order does not indicate that any of the said dispute is being examined or adjudicated. Full stop.
It's a humble request to remand it back to the single judge. So that
View of the about the petition is allowed. It will clearly it's also not be apposite to examine such distribution. The petition is, the appeal is allowed, the impugned order is set aside, the appeal is allowed, we are prosecuted. How we clarify that I'll just say the appeal is allowed and the impugned order is set aside. How we clarify this will not preclude. Another decision to follow where similar direction will be. entitle you to reimbursement.
My lords, in the other case also, there were not such clauses.